This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about the effect of a man bites dog story where Allstate and Allstate groups of insurance companies sued 42 defendants in New Jersey for fraud under the no-fault insurance program in that state, forcing the courts of New Jersey to deal with a lawyer who represented 35 of 42 defendants in the fraud case when he was presented with an insurmountable conflict of interest, since alleged fraudsters had obvious conflicts with each other. In the case entitled Allstate Insurance Company et al. Versus Robert Matturro, D.C. et al., and the New Jersey Department of Banking and Insurance as an intervenor, the Superior Court of New Jersey Appellate Division on June 16, 2025, dealt with the fact that Allstate and several related entities sued 42 defendants, including medical practices, their owners, administrators, and various corporate entities. The plaintiffs alleged that the defendants engaged in an insurance fraud scheme involving unlawfully structured medical practices, self-referrals, kickbacks, and medically unnecessary treatments and tests. The Allstate plaintiffs sought damages for personal injury protection benefits paid to the defendants, compensatory damages for investigating fraudulent bills, arbitration-related cost, a declaratory judgment, treble damages, injunctive relief, and attorney's fees. The Randolph firm represents approximately 35 of the 42 defendants, including several medical practices and corporate entities. Plaintiffs moved to disqualify the Randolph firm from representing these defendants due to significant risks of conflicts of interest. The Appellate Division found that there were significant risks of conflicts developing among the defendants represented by the Randolph firm, especially in the case proceeds and liability and damages may need to be appropriated under the Comparative Negligence Act. A determination of whether counsel should be disqualified, the burden is always on the moving party, to prove a basis for disqualification. When deciding a motion to disqualify counsel, courts must balance competing interests, weighing the need to maintain the highest standards of the profession against a client's right to freely choose his or her counsel. Motions for disqualifying, therefore, should be viewed skeptically in light of their potential abuse to secure tactical advantages. Nevertheless, if there is, quote, any doubt as to the propriety of an attorney's representation of a client, that doubt must be resolved in favor of disqualification. The Appellate Division concluded that the trial court erroneously found that there was no significant risk that potential conflicts could arise among the approximately 35 defendants represented by the Randolph firm. The Appellate Division held that there are significant risks that conflicts will develop among defendants represented by the Randolph firm. Even more, there is evidence that significant conflicts of interest have already developed between and amongst the numerous defendants represented by that firm. The certifications and depositions provided by the plaintiffs support that conclusion. Moreover, There are significant risks certain defendants may, as the facts develop further, assert that other defendants had a greater role in the alleged fraud schemes or compelled them to participate in the schemes. If those situations arise, the Randolph firm could not ethically advise all defendants because of those conflicting interests. Fundamentally, at least some defendants maintain that Rosania and Matturro managed the Rosania entities, and they controlled the finances of the Rosania entities. In response to plaintiffs' interrogatories, the Randolph firm served the expert report of Gary S. Stetz, a certified public accountant, and in his report, Stetz made two findings which are potentially detrimental to the positions advanced by the physicians represented by the Randolph firm. First, Stetz noted, his investigation found that none of the Rosania entities would require a medical doctor or doctor of osteopathic medicine to perform examinations and procedures which were controlled by doctors chiropractic. Second, Stetz determined there was no medical doctors or osteopaths who were employed by Matturro or Rosania. In seeking to minimize the liability of some defendants it represents, the Randolph firm would have to argue that the other defendants it represents were more at fault or perhaps more involved in the alleged fraud scheme. The record in this matter establishes, the court of noted, that there are significant risks that conflicts will develop among the defendants. As stated, defendants have a common interest in disputing the allegations against them, but as the case develops, they also may have an interest in seeking to minimize their own liability and maximize their co-defendants' liability. If plaintiffs' claims proceed to trial and there is a verdict against the defendants, the liability and damages will have to be apportioned among the defendants under the comparative fault statutes. Therefore, the Appellate Division held there are significant risks of conflict arising among the 35 defendants represented by the Randolph firm, especially in light of the pending trial date that requires disqualification. In my opinion, a firm that represents 35 different defendants who are claimed to have defrauded the plaintiff using various different schemes, where one can and must have different interests than other defendants, is simply untoward. Disqualification was required since the lawyers, to represent their clients properly, will necessarily find one client adverse to the other and will be unable to fairly represent each of its clients. In a perfect world with 42 defendants, there should be 42 defense firms protecting properly the rights of each and every defendant, not one law firm representing parties with different interests and different defenses. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and access to the more than 5,100 blog postings. Please tell your friends and colleagues about this blog and the videos on YouTube and rumble.com so that they too can subscribe. And if you watch these videos, please click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.